Anyway, for premium members, let me just say something now that I have this open. While I have this open, this is where most of the premium content can be found. You see these menus with the little arrow? That's an arrow, that's an arrow, that's an arrow. Usually you can click this, like here's this one for example. When you click this, yes, the page refreshes and you have some more content here. But this is also, notice down here, now there's a little drop down menu. It says fixing credit. It has premium. So this is where if you're premium content, you would see this if you're in a premium subscription group. If you don't see this, then you're not in the group. Okay, so that's where you can click this and it'll take you to something specific that you have access to. Most of everything that I'm about to cover in this lecture, as coincidentally, it will be exactly here under credit and FDCPA strategies for the premium subscription group. So I'll be loading it under here. So if you don't see it under here just yet, give me a good 4 or 5 days after this video comes out, because I'll still be loading the content. So it'll be under here. And if you really are working on your credit, like right now over the weekend or something, and you feel like, well, I really want to work on this right now, and you're in the premium subscription group, shoot me an email and I will send you the PDF. The PDF is this. Now again, I'll probably this is just my notes really, and that's what I'm going to be going over in this video. And it basically starts here. You see it right over here. It's about 3 pages worth of my notes. And these notes is everything that you're going to basically need. You're going to really enjoy this. You're going to really enjoy this. And I'm going to try to go through it real quick because all the content is right here. Now what I'm basically giving you is a flow. It's an outline. The only thing you have to bring is the 5th element. You know what I'm saying? Bring your brain power and make it all work. Okay, but I'm giving you the layout. You can take this in so many different directions, whether you're dealing with the credit reporting agency, whether you're dealing with the debt collector. There's a lot of different angles in here, and you will get anything off your credit report for the most part. The one thing that I did not address in here that I just kind of thought about right now is I didn't really address judgments and things like that, which I'm not an expert at getting those things off, but I do have some ideas and I do know some ways to get those off. Not just judgments, but liens and court things. But everything else from creditors and and mortgages and things like that, I think things that are not really verified, this should help you right here. And if not, add to it. I definitely, there's definitely something in here that you will benefit from, and I'll tell you why. Foremost, we're discussing 2 things in here. Bring this down a little bit. The Fair Debt Collections Practices Act, which is really what you pretty much are going to be using mostly against debt collectors and people trying to actively collect the debt, and many of those are going to also be reporting things to the credit agency. So you've got the Fair Debt Collections Practices Act, but more importantly, the Fair Credit Reporting Act. And I had to kind of slap myself upside the head and say, what was I thinking? Like, why? It's not that I overlooked it. I knew about the Fair Credit Reporting Act, but typically, for whatever reason, when we think about fixing our credit, we talk about the Fair Debt Collection Practices Act, which there's some very powerful things in there, but the Fair Credit Reporting Act is more powerful. So the flow of this thing is this, though. All these notes, the whole goal of this is just clean your credit report up, basically. So the very first thing you see on here is I have complete the affidavit online. I should have had a note up here. This is the affidavit of identity theft. So this is one. This link will take you to one that's on the. This will take you to a step-by-step process. Here, I just clicked it here, right? Web page pops up. This takes you to federaltradecommission.gov. The Consumer Financial Protection Bureau, which is kind of like the consumer's protective agency within the government. They basically have a template for an affidavit of identity theft, and so does the Federal Trade Commission, because basically the Federal Trade Commission controls the Consumer Financial Protection Bureau, I believe, if I remember from my research correctly. But anyways, here's their affidavit of identity theft, and you can go through here, I suppose, get started, and you fill out all these things and you answer all these questions, and then they will populate a PDF and print it out for you, and that'll be your affidavit of identity theft. Where's my notes? Oh, I lost the notes. Give me 1 second, folks. Okay, sorry about that. Okay, here's the notes. So they will do that, but me, I don't like using government forms. Some people really don't care. There's no right or wrong answers. How make your own determination. So here's another. But now here also, this is actually what they're populating. So we just looked at this step-by-step thing where you fill this out. When you finish this and you hit submit, I'm pretty sure that if I remember correctly, this is what you're going to actually be auto-populating, and then you just print it out and sign it in front of a notary, and this will be your affidavit of identity theft. Now, how does this work? All the accounts that you're reporting, see, let me go back to my notes here. Now you're going to see how these notes are working. The reason I have these affidavits of identity theft here is because in my research, I learned this is like a little nugget for everybody, and this is the citation. This is where it says it under the Fair Credit Reporting Act right here. But it says, if a consumer notifies you that he is a victim of identity theft and gives you an identity theft report, you may not furnish information to a credit reporting agency regarding the fraudulent account or debt. So this is for those who are furnishing information to a reporting agency. So if they receive an affidavit of identity theft from you, doesn't care. It doesn't really matter how they feel about it. Doesn't really matter if they say he's lying, whatever they protesting, unless they got any proof of the otherwise, unless they have any first-hand knowledge or whatever. This basically says they may not report or furnish information on a fraudulent account or the debt. And I found out that holds true quite consistently. This is not something you're really gonna have to argue about. But now sometimes, now this is supposed to be accompanied by an affidavit of identity theft and a police report. Yes, this works a lot of times without the police report. A few times I've seen some contention with not providing the police report. A lot of people feel funny about going to get a police report of identity theft for certain reasons. Some people feel funny about it and they don't do it. Other people don't feel funny about it and they do it and they get this done and be done and over the fence already. And others are still sitting there. And then also look, because a lot of these places will take the police report online, and I think you just want the number because, like, for example, if you look at their affidavit, I think they ask you, has a police report been submitted, and they want to know all that. You can just submit your own police report or your own affidavit of identity theft without the police report. So make your determination. With the police report, it happens faster. I've seen things get removed in about 2 weeks. It happens pretty quickly. So let's see. That is, and that's where you read it at. So these were those two affidavits of identity theft. Here's another option, right? This is from I think that's Arizona or something. They have a template affidavit. Let me move this up. Yeah, this is a better option. So you can use this, right? Because this is not basically, it's not a government form. But every time you use a form, just keep in mind that they're limiting what they want you to say. They're giving you options when you use a form. So you may want to consider looking at the form to get you in the right direction and just freehanding your affidavit. Or you can use a form and write extra in, but just be cautious when you're using a form that they're to some extent that's limiting you and restricting you, because the affidavit is very powerful in this whole matter here. So that's the first thing. So we say the affidavit, that's why that's at the top of this document, because that is kind of your quickest thing, your first thing you order report. I don't like this, I don't like that, highlight. Okay, this is for entertainment purposes only. This ain't legal advice and all of that, and I'm not telling you that you should go about this type of procedure or process for cleaning your credit, but I'm just talking freely. Okay, so you get it. I don't like this, highlight, affidavit identity theft, throw the shit at the fan and see what sticks. I'm just playing. I shouldn't say it like that. But the truth be told, I'm just keeping it real. That's going to be the biggest punch. Knock a lot of stuff off without you having to wait up at night doing a lot of excess extra work. So that's the first part. Now, after you see what's remaining, now we further ourselves down the document and go into some of the other strategies that are already prepared for you in here. So that's just showing you the flow of the document. Now let me bring this little notes up right here, and then I'll close out of this. I just talked about the Affidavit of Identity Theft. That's not really on here, but we're going to be talking about the Fair Credit Reporting Act and the Fair Debt Collections Practices Act, which is FCRA, Fair Credit Reporting Act, and FDCPA, Fair Debt Collections Practices Act. And I decided to slow down a little bit because I really want you to understand this. I want you to understand these magnificent tools and the flow of what I put together so that you can use this to help yourself. I really want you to, because there's template letters and everything in here, all the way up into examples of lawsuits that other people have filed that you can really use as an outline to file your own lawsuit in small claims court using these same template letters to certify your facts and your records via administrative procedure. All that has been put together here. So I'm going to slow down just a little bit. I try to speed up because I want the video to be short, but I'm going to slow down so that you can better understand what is here. So the flow is, we started with the affidavits, identity theft, right? Knock off whatever you can knock off with those. Then we'll get through the dispute letters. These dispute letters, there's some templates in there that you would send to the credit reporting agencies. These are like your TransUnions or your there's some other ones too, like what is the one, the main ones, like when you go for a job and they run your background information, like Verichecks. All of those are reporting agencies. TransUnion, Experian, of course, all of those. But though, so let's see. Yeah. So after you do the affidavits, you go through the series of letters, which these are fashioned where you send the first letter off and you indicate the account and the issue, letting them know that they need to, either take the remedy, which is verify it, provide proof of the contract, or whatever it may be, or default. So this is your administrative procedure letters, and these are the typical letters. Is the way that people, they're not typical letters. Actually, these letters are very powerful. But what I'm saying is, when you use the letter technology, sometimes there's usually some back and forth. You send the first letter and they're not going to remove it. You send the second letter, they're not going to remove it. And by the time you're hitting them, usually around that second letter, that third letter, they're removing it, if your letters are making sense and you're not just sending some random stuff off. That's why I said you got to put your brain in it. There's a bunch of templates in here, but we go through the affidavits, then we go through the letters to clean stuff up. The letters simultaneously, if you're doing these with a third-party witness or a notary presentment, now, so let's say like this. You don't have to do that, but if you want to make your letters stronger, use a notary presentment. I'm not going to explain what that is. For those who know what that is, that's cool. If you don't know what that is, it doesn't matter. You can still send these letters back and forth to clean your credit, and use the Fair Credit Reporting Act as well as the Fair Debt Collections Practices Act. Okay. Now, at the end of these letters, when we're asking them to move this derogatory information because it's not verified or for whatever reason, these letters also include intent to sue letters. So what the thought process that you have to go through is that while you're sending them the first opportunity to cure, and they can't verify it because they don't have the proper records and they don't verify it, but they default and they keep reporting, you're telling them they damaged you, that they're defaulting to their obligations under the Fair Credit Reporting Act or the FDCPA. So in addition to being damaged, they're defaulting under government acts and laws and this, that, and the other. So while you're doing all of this, you're keeping a copy of everything. You're using certified mail. Maybe you're using a notary, but it's of the utmost importance that you keep precise records. This is why you don't rush this stuff. This is why I take my time when people's emailing me and calling me and trying to get through and saying, oh, it's urgent, I got an urgent matter. I know that things never, you never need to rush anything. Sometimes you just have to experience and just learn and be ready for next time. So, it's the same thing. Take your time with this. When you're doing your records and you're sending your documents back and forth, keep precise records, because those are the facts. Those are your administrative records. And when you send that intent to sue letter, you're not going to send an intent to sue unless you're about to go and sue them. Now, I personally have never sued a debt collector in small claims court, but I know of many people who have. Not many, but enough. And what I usually hear is that half of the time you win by default because they don't show up. And when they give you that judgment, you go get that check, and you'll get paid out your $3,000, $4,000, $5,000, $10,000, whatever it is. So this is the flow of what we laid out. Affidavits, clean your credit report. Letters, clean off whatever the affidavits don't clean off. The affidavits, identity thefts. Try it with your student loan stuff and all of that. There's other things too. These notes will always be getting updated, but this is just what you have in here right now. The intent to sue. By the time you get an intent to sue letter, if you've done, as you'll see, what we've laid out in here, I think that's going to be the end of it. I think they're going to stop reporting whatever is derogatory. And by that time, if they don't, hey, now it's time for you to experience small claims court and really master this. So now if you add the fifth element, which is your own brain power, on top of what I put together, you are going to be dangerous, because I just saved you a lot of time. How do I know? Because I've been thinking about this stuff for well over a year now, but just being able to put a little bit together at a time. As you see, a lot of people say, like, yo, you're putting out real great work right now. I didn't just start doing this. A lot of this stuff I've been working on for years. So y'all seen me put out stuff about Fair Debt Collection Practices Act. Now, I go back into those same notes, and then I start adding on top of it what I know. A lot of these different links and PDFs that you see I'm linking to, I've been saving and storing this stuff. So now I got to get it out there in the cloud. So anyways, let's get into it real quick. I pretty much told you what it is, so now I'm going to breeze to it. Those are the affidavits of identity theft. We looked at it. You click this so you can read what the Fair Credit Reporting Act is. This is the Fair Credit Reporting Act of 2012. I like this because it's just easy on the eyes to read how they put this together. It's all laid out. The short title, subsection 602, subsection 603. It's all laid out well. That's why I like this one. It is, congressional findings and statements and the purpose. And this is the Fair Credit Reporting Act. But this is laid out really good. And you can read this and figure out what their restrictions are, what they can and can't do under this act, what the obligations are. This is probably one of the best places I've seen how it's put together. That's why I put this link here. But at the same time, it does say 2012. But browse through it. You're going to learn a lot. Where's the notes at? Let's close out of here. We don't need that no more. Don't save it. Alright, so read through the Fair Credit Reporting Act. Here's another place you can read about it. Okay, no, this is important. This is a summary of the Fair Credit Reporting Act. This is something that the FTC provides to credit reporting agencies and other people who furnish information to them. So read this PDF right here. These are just notes. That kind of shows you, this is more about Fair Credit Reporting Act, showing you basically what they can and can't do. So you have to be familiar with the Fair Credit Reporting Act. These tell you exactly what they can and can't do. You have to be familiar with them, because when you get into writing your letters, which we've provided some templates here, you can specifically cite, this is what you can't do, here's where it says you can't. So that was the Fair Credit Reporting Act. This is the Fair Debt Collections Practices Act. Once again, Fair Credit Reporting Act is going to be for those people who furnish information to TransUnion, Experian, Equifax, Advantage. I think that's one, like Advantage or something. What's the other one? It's a whole bunch of these agencies. I wish I knew a lot of those little under the radar ones. I want to call their name out. But they're the Fair Credit Reporting Act. Then you got the Fair Debt Collection Practices Act, which is, that's more for your debt collectors and things like that, and your collection companies. Here's some other things about aging of accounts and all of that. You can read that. Okay. But you should really click all these links, because I put all these links are showing you things that they cannot do. If you find that any of these apply into your personal situation, then you need to throw that in the template letter of how they're violating the Fair Credit Reporting Act or the Fair Debt Collection Practices Act, along with your validation, or etc., etc. And you got to set them up for that lawsuit, which when you get down here, you'll see the templates. We're going to get to them in a second. So these are dispute letters. These are just, so up here, these links familiarize you with the acts, what they can and can't do. Here's your dispute letters. The first, here's your cover letter for the affidavit of identity theft. We talked about it already. It basically says, notice, now this is very important also, with all your cover letters, something I'm learning, you got to send an image of the social security card and some form of an ID, government ID. Why? Because you're asking them to fix this stuff, and by not sending that stuff, you're not going to get it fixed any faster. Just some other things I'm learning and things like that. You want to send them that because you just really want to get this thing done and knocked out. You don't want to mess around with this. You want to get this stuff fixed. So this right now, you're letting the CFO of the company that reports information to the credit agency know that you've been affidavit of identity theft, that you've been victim of identity theft on this account, that you feel whatever. Dear Michael Jones, CFO, I'm sending this communication to provide you with the police report and this affidavit of identity theft, which has been submitted to the FTC regarding the above mentioned account. In addition to this notice, I previously requested that you validate the debt and or remove the account from my credit file. See, so you can hit them with a sequence. Maybe you were first sending the letters first, which is a good strategy, and then boom, you hit them with the affidavit of identity theft. Make sure your letters make sense if you're doing that, or maybe you hit them with the affidavit of identity theft, and while they're supposed to be handling it, you hit them with a letter too. You know, sometimes you got to do what you got to do to get it done. You have not properly responded, and you continue to use my information in connection with this account. In addition to your obligations under the debt collection laws, you may no longer report on this fraudulent account. You put the citation in there. And then attached to it, you got your affidavit, your copy of your ID, the copy of the debt collector letter, or the copy of your credit report, whatever you're trying to get removed. Okay? Now let's see. That was that. We already went through the affidavits. You can create your own affidavit. I like this last one, the last one that we looked at. Here's the dispute letters. I put them all on one thing. There's a bunch of different dispute letters in here. We'll start with the first one. The first one goes to the credit reporting agency. So this one naturally is going to be under the Fair Credit Reporting Act, which you can see is Fair Credit Reporting Act. Just going to touch on some points here. You can open it up two different ways. That's why you see these two red things. I'm in receipt of my credit report, which reports a number of inaccurate items which seem to have been published by your company. The accounts in question are as follows. Then you list the accounts. For example, Bank of London, report 60 days late, and under here I have unverified. This account does not belong to me. Right? Or I could have just scrapped this whole beginning and said, this is an attempt to correct inaccurate information being reported in my credit report published by your company. Upon being denied credit due to the information being published in my credit report, I found a number of items in the report that you were publishing which are inaccurate. That could be worded better. The accounts in question are below as whatever. So see, there's some options here, but there's some verbiage, so put it together, make it make sense. Then you say, I have no record of the above accounts, and I'm demanding that you disclose all the documents upon which you are relying on for reporting on this account, or reporting on accounts 1 and 2 above, collectively referred to as counts. You can word this better. Let's see. In accordance with your obligations under the Fair Credit Reporting Act, in accordance with your obligations under the Fair Credit Reporting Act, the consumer is entitled to the records requested. The information you are reporting is harming my reputation, is adversely affecting my credit worthiness, and I'm being denied credit as a result of this inaccurate reporting. I am therefore requesting and demanding that you remove these accounts from my file within 30 days in accordance with your obligations under the Fair Credit Reporting Act, or send me copies of the documents that you have in your files as of this date that you rely on for verification of these accounts. In addition to the above notice and request, whatever, you can read the rest of it, but that's the That's like an initial letter. So you know, make it personal, put your certified mail information in there, send it to the credit reporting agency. Let's see. This is, now here's a non-response letter. There's a couple of type in here. Here's one. This, dear credit reporting agency, this is after they didn't respond after the 30 days or whatever. This letter is to inform you that you did not respond to the disputes regarding the following accounts in my credit file. You list the same accounts. As a consumer, I am entitled to a response within 30 days of your receipt of my dispute letter. This certified mail tracking number of my original dispute, for which I have attached a copy of the original letter, was received by your office on X date, and as of this date I have not received the response. The information you are reporting is harming my reputation. It's adversely affecting my credit worthiness. As previously noticed, in accordance with your obligations under the Fair Credit Reporting Act, if you do not have any documentation in your files to verify the accuracy of these disputed accounts, then please delete them immediately. I am requesting and demanding that you do so under the Fair Credit Reporting Act, blah, 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 blah. And then again, you're always putting a copy of your social security number, copy of the license, copy of the report, whatever, right? So again, you don't have to do this because it's already done. That was a default letter. Here's a different type of default letter. You can read it. It's just another form of a default letter. Second notice that the inaccurate and unverified accounts for my credit report is a violation of 15 U.S.C. 1681. You are required under the Fair Credit Reporting Agency to have properly verified the accuracy, blah, blah, blah. That's a more longer one. It's still saying you didn't respond. Here's a third notice. You still didn't respond. You sent them a 1, 2, 3. Notice of intent and pending litigation seeking relief and monetary damages for violations of the Fair Debt Collection Practices Act or the Fair Credit Reporting Act. So now this is when you're about to take them. You're telling them, hey, listen, I'm about to take you to court. All right. This is now those letters, all these letters that we just looked at, those are under the Fair Credit Reporting Act. So again, go back to the notes, read the Fair Credit Reporting Act, these two things right here, showing you what they can and can't do. There's another place in here too. We'll go down here, I'll show you real quick. All these notes in here. Fair Credit, where's it at? Where's it at? Summary of rights under the Fair Credit Reporting Act. These are excellent documents, folks. Let's click it real quick. It's breakdown. This just gives you a breakdown of your rights under the Fair Credit Reporting Act. So you want to be familiar with those, because when you find out that they violated any of these rights, these are the things that you're going to be working into your letters, into your administrative presentment process. I'm going to show you some other things with that, but there's something else I want to show you. There's a lot of breakdowns in here of the Fair Credit Reporting Act. Where's it at? Where's it at? Anyway, these are more breakdowns. You have the right to demand that these, let's see, under the Fair Credit Reporting Act, and this is where the section is, you can, you have a right that they disclose the documents in their records and retained in their file in regard to the accounts that they're reporting on. Something like that. You can go look at these citations and see exactly what they say. If they don't have any of the documents in their files to verify the accuracy of those disputed accounts, they must be deleted immediately. That's under the Fair Credit Reporting Act there. It also says inaccurate, incomplete, unverified accounts must be promptly deleted. If they don't investigate or respond to notifications of dispute within the specified times, the credit reporting agency must delete the disputed information. Here's another citation for that. They cannot under well, I don't know what I was writing there, but they can't report information on you that the consumer tells them is inaccurate if that information is in fact inaccurate. Citation there. Most of all these things under the Fair Credit Reporting Act that they can't do, that comes out of that first document that we clicked up here, what information furnishers are required to do. This right here. But anyways, the first set of dispute letters was for the Fair Credit Reporting Act. These dispute letters coming up here are for the Fair Debt Collection Practices Act. So notice these are a formal request for debt validation. And these are focused on different things. So you have to read them, see which ones apply, and go through your administrative procedure. Now this is something I like to do. If you got one of those things and they are abusive debt collector and they are violating Fair Debt Collection Practices Act, call them on the phone with a pen and a paper, and any violation that you notice, write it down so that you can create a written record of it. Notice how this letter is structured. This is a complaint against Deborah, last name, employee of debt collector company, regarding her abusive practices which may violate the debt collection laws. On or about Thursday, July 28, 2018 at 2 p.m. I received a call from whoever she was, and she said, as an employee of the debt collector company, that the above referenced account was closed by the original creditor on whatever date. And then she said blah 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 blah. And then you say whatever it is you're trying to say, and then you say by reporting the account as open, you are in violation or whatever they're doing. So this is not making sense, but you got to make it make sense with your situation. But by doing this, that, and the other, you are in violation of the Fair Debt Collection Practices Act 15 USC by falsely characterizing the account as an open account when the account is indeed closed on whatever date or whatever you're saying. And then you can say some more stuff in there, and then you close out the letter and you send that to them by certified mail or whatever. Why? Because if these people don't stop reporting stuff on your account and they're not responding to your documentation, you want to have some records of the business relationship, which is they're reporting on your credit profile. You've disputed this, you've done your due diligence, so you can take them to small claims court and rack that 5 G's up off them right quick. So these are letters in here all the way to getting you to the point of filing the lawsuit. Notice of here's another intent to file lawsuit. There's 2 letters like that, and then there's a letter that you send them to let them know that you filed a lawsuit against them. So it says, I have sent previous letters to you, all by certified mail, copies of receipts enclosed, requesting that you remove inaccurate information from my file, and you have failed to do so. Accordingly, blah 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 blah, and you're letting them know that you're gonna sue them now. Okay, so where we at? We went through, you got these dispute letters, right? Now, what I just kind of talked about, most of you already know, but you can read this here. Let me see what I have here. These are several template letters to start and complete an administrative fact-finding tribunal. That's what I called it. Administrative fact-finding tribunal. Tribunal. I'm talking about when you're sending the letters back and forth. Remember, you're creating the facts just in case they don't remove these items. They're in default by not responding, so that's what you're going to take them to court as the proof of the evidence of your contract to which they're in default on. You're basically bringing the default into court to get liquidated against their agency, company, or whatever. Let's see. So here's a little bit of administrative procedure. You can send them the opportunity to cure and the notice of fault and all of those type of things. This goes without saying. You can read over this if you need to understand that. Most of you advanced people understand administrative procedure right now. Here's some more links here. Let's see. These are for your records, so be certain that they establish the elements of your case. They must demonstrate abusive debt collection practices in the event of the FDCPA or reporting violations in the case of the FCRA. So I guess what I'm trying to say is those template letters that I have, they're kind of very specific as to showing defaults under the Fair Credit Reporting Act or the Fair Debt Collection Practices Act. But a lot of the abusive behavior and things that they might do might not be covered in a template letter. That's when you want to create your own record of the conversation and then send off a complaint letter. Send off a complaint letter detailing what took place, because now you're creating a record of facts. Now, something else I was going to mention here. We were talking about creating a records of facts. Now, I want to briefly mention the Consumer Financial Protection Bureau and their administrative process. So here's the Fair Debt Collection. Comes from the consumer. This is not what I was trying to reach, but what I want to say about the Consumer Financial Protection Bureau is they are basically operating as a administrative oversight, or that's not the proper term, but what I'm saying is this: if you complain about any debt collector to the Consumer Financial Protection Bureau, they're going to automate a process. They're not going to directly get involved. They're just going to stand in between and witness the communications between the two of you. So all of this stuff I've been talking about with the request to validate the debt and all of that, if you really want to think on a higher level to make this even stronger, you can take these same requests for debt validation, you can take them through the Consumer Financial Protection Bureau by just simply sending your correspondence through them. And what they're going to do is they're going to receive it and they're going to forward it on to the debt collector. So that's just something to think about. I don't want to get way into that. It's beyond the scope of this. But you can investigate that. Many of you already know how to do that because of what you've already been working on. So these are more good things to check out. Look at this. This is a list of what they can and can't do under the FDCPA. That's in here for the FCRA too, but let's just click this right here. FDCPA Overview and Violations. You want to know this. Fair Debt Collection Practices Act. Look at these PDFs. Definitions, overview. Everything is laid out. Requirements and prohibitions. They cannot discuss the debt with a third party. This is where it is. If this is what they're violating, this is exactly what you're going to charge them with, and that's the statute. So it's all laid out. Can only contact a third party one time for the purpose of obtaining information. Statute. Slice them with it. Can't call before 8 a.m. or 9 p.m. Slice them with it. Cannot contact a consumer if known to be represented by an attorney. Slice them with it if it applies to you. Cannot contact the consumer. There's a whole bunch of abuse, harassment. It's a whole bunch of things here that they cannot do. Collector can't publish list of debtors, advertise. It's so many things. But now, when you get into the Fair Credit Reporting Act, let me show you, by the way. Here's another list. That was a list right here. That was the overview. We just looked at this. Here's a whole nother list. It's from somebody's website, but it's good. Illegal debt collection practices. Same thing. 15 U.S.C. 1692. They're dealing with the Fair Debt Collection Practices Act. They tell you all kind of things they do. Cannot identify their employment unless asked. Cannot state that you owe a debt. Tells about their communication with you, harassment, abuse, false or misleading representations. This is how you can really get them on the phone. If you call them and you start asking them about the status of the account and did they purchase the debt and at what date, and they tell you, well, we don't want to give you the information, then you have to know your rights under the Dodd-Frank Act, the Consumer Wall Street Act. There's a such thing, and I put it right here. FDCPA Dodd-Frank guidance. There's a such thing called the consumer's right to know information. A lot of these, you can look under the on thctrust.org, go under the public information requests documents, and you'll see a lot of that information, the consumer's right to information under the Dodd-Frank Act. And it's also, you'll find those notes in this document too. Basically, when you get them on the phone and you start asking them, did they buy the account? What day was the account charged off? Did the account number change? And they start getting nervous, and then they start trying to talk around you. You start saying, hey, are you making a misrepresentation? You gotta, you can't make any false representations in connection with collecting a debt. Those are all violations of the Fair Debt Collection Practices Act. And then when you remember who you spoke to, that's when you go back into that letter like I was sending you. Dear CFO, I am writing because I am, concerned about the behavior and the integrity of your employee when they were making false representations about this account. Blah, 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 blah. So, right, all of this is to take you and get you ready for this lawsuit that you may have to file. Now, by the way, I'm making this very complex and difficult just in case you're that one person with the debt that didn't get removed with the affidavit of identity theft or the letters. I don't foresee many people having to go this far, but if you want to, and if you just feel like, hey, you want to sue them anyway, see how the small claims court thing is, you can use the extra recovery of $5,000 of maybe which you was damaged, then by all means. But anyways, let's see. There was something I'm missing here that I want to show. Oh, here it is. So, where is it under the Fair Credit Reporting Act? I had something for you guys. But I guess it's these two right here. These are your Fair Credit Reporting Act breakdowns. I thought I had more on the Fair Credit Reporting Act, but these are definitely enough. I have more on the Fair Debt Collection Practices Act. But the letters are pretty much already done for the Fair Credit Reporting Act. So now, I wanted to show you this. Common points for Fair Credit Reporting Act response and cross-claim. So if one of these debt collectors is coming at you, this is a template for a response and a cross-complaint. Cross-complaint for damages and injunctive relief, declaratory relief, and accounting for violations of the Fair Debt Collections Practices Act. So this is when they're ruining your credit and they're trying to threaten to sue you, or they do sue. This is your cross-complaint, and this is your rebuttal and your estoppel. So you got to read through this. Now, so this is your setup right here. Notice it starts with your general allegations, common clauses to the action. I'm not going to read through this, but, well, let's read through a little bit. Debtor was at all times the individual who maintains the principal place of business at the residence. The cross-defendant asset acceptance, that's whoever's your debt collector or whatever, is at all times was a limited liability company organized under the laws of Delaware. Cross-complaining is a consumer within the meaning of the Consumer Legal Remedies Act. Okay, Consumer Legal Remedies Act. We might want to look that up. Cross-complainant is informed and believes and therefore alleges that the cross-defendant asset acceptance regularly uses the United States mail in regular collection of debts, etc., etc. This is one of the requisites to fall under the FDCPA. Now, let me mention something here. This is very important for anyone who's going to file a lawsuit. I recommend you get your hands on a copy of Jurisdictionary. I think it's very expensive, though. I don't think I would buy it for that price, but I think I would look around on the undercover network or whatever, ask different groups, check around, see if I can get my hands on Jurisdictionary, because if you're going to file a complaint under the FDCPA, the Fair Credit Reporting Act, Quiet Title Act, RICO Act, human rights violations, no matter what complaint you're going to file, there has to be certain elements to make that recipe complete. There has to be certain legs underneath a surface to make a table. So what I'm saying is, when this person just said they believe Acceptance LLC regularly uses the United States mail in the collection of the debts, that's one of the necessary elements that must be in place for this to even be taken seriously under the Fair Debt Collection Practices Act. So to learn more about, so basically, in order to have a chance at winning this case, you have to make sure that if you're claiming they violated the Fair Debt Collection Practices Act, then your case meets all the elements. One, they have to be a debt collector. This is an element proving they're a debt collector. They use the United States mail to collect the debt. Two, so how do you find out what these elements are? The easiest way is Google. Google elements of Fair Debt Collection Practices Act violation, elements of Fair Credit Reporting Act violation. Best thing is get your hands on Jurisdictionary and let them break down to you about the elements of the claim. This is just a little inside thing. You don't have to do all that. A lot of the times where you're going to be taking these cases in small claims court, you're not even going to have to do all this. This is just provided for you. A lot of times it's going to be a small, simple form. You're not even going to have to do all this. But if you did have to do it, you have a couple templates to look at. So, but you always have to do venue, jurisdiction, etc., etc. But you want to find out what the elements are, because the elements are going to be laid out in your facts. And the elements are also what you always want to be thinking about, because when you look at the letters and the communications that you were going back and forth, some of those elements are going to have been proven within their defaults in the communication, right? So you're establishing facts by the communications. They really can't win. I don't foresee you having to get this far. But, and really me even telling you about the elements to be the debt collector in small claims court is above and beyond. But if you do all these stuff, you should really win. You should be blowing them out the water, right? So anyways, you put your little claim together and you file it. So this is a template right here. That's within these notes. And that's for the Fair Credit Reporting Act. Here's something else, substantive defenses. This is also, I put this in here because this is also dealing with mostly the Fair Credit Reporting Act. This probably deals with the Fair Debt Collection Practices Act also. But there's a lot of good templates, I believe. I'm thinking at the end of this document, look at that. They got a bunch of different templates to file answers, and they might even have claims, but definitely answers. So if a creditor, credit card company, debt collector is filing a case against you, then you want to go through these things, help yourself learn how to answer these bad boys. So it's just another reference in here. We went over these list of violations, more violations, illegal debt collection practices, case styles. Here's something to help you if you think you're going to have to draft a case. Look at this. One thing I'm thinking, you can always, these are federal claims mostly. So really, but you can still bring them in a small claims court for a quick remedy. All that's above and beyond the scope of where you're going to use this. I'll let you figure all that out. But here's a nice document I came across, and you can use this as a template to help you freelance and draft your own case or your claim. And you can see that some of the templates, like the one I just clicked, kind of follow this structure: nature of action, jurisdiction, parties, venue, factual allegations. Most of this stuff, I think you can. Most of this stuff is talked about in the rules of civil procedure. They talk about the jurisdiction. They talk about who can be the parties. They talk about the jurisdiction, which is or the venue. They kind of address these things, but this is an outline, which you probably can. But notice how you can have account violation of the FDCPA. Then you can have account 2 violation of another something else. But we're probably going to be doing FDCPA and Fair Credit Reporting Act. So this is just something to help you set it up. Jurisdiction, parties, venue, the facts, which is where where you will reference all your administrative records, your letters, and whatever, and all the elements. You will make sure that you addressed all the elements to support these counts right here, these accounts, right? And that's what you're basically going to charge them with. So that's for the more advanced, because I know the majority of people is not going to be freestyling that, but that's a case styles document. Here's an FDCPA template. Hey, check that out. That's good. That's a good find right there. So that'll help you set it up. Notice you see these same things. Jurisdiction, right? Parties, same type of things. Allegations, that's like where your facts. Notice the setup, you know. Now he's asking for the damages, the violations, right? Notice how he says, here's count 1, violation. This is why those references, all that reference material to show you what they can't do, and then putting the citations of where it says it in the Fair Credit Reporting Act or Fair Debt Collection Practices Act. This is why it's good. And then notice he put the Fair Business Practices Act. So not only do you have the federal FCRA, FDCPA, there's a version of that in your state also. So anyways, that's a template, help you get on your way. Here's a template for an appeal, which actually went in the favor of this young lady, and this is in Georgia also. So this is good. So this is a United States District Court appeal, and they have Fair Credit Reporting Act, Fair Debt Collection Practices Act, very specific things. Notice how they mix the two. More power in the Fair Credit Reporting Act. So now these things are supposed to be liberally construed in your favor. So most of the times, by the time you hit them with that intent to sue letter, they're going to run screaming. Now I have a colleague that says if you really want to scare them, put a draft lawsuit in there. But now I say don't threaten, just do it. Now check this out. For those who want case law, man, I'm not even going to click these, but between these two links right here, this is all the FDCPA, FCRA case law that you need right here. I think Golden Cases this is FDCPA and FCRA, I'm pretty sure. But yeah, between these two, these are two different documents too. There's so many case laws in your support for many different states and jurisdictions. You want to check these out. I'm not even going to go into them. A violation of the FDCPA. Okay, so here's something else. A violation of the FDCPA is also an unfair or deceptive act or practice. Federal Trade Commission Act. So you can take your records, send them to the FTC, or just put them in a database by using that third-party method, Consumer Financial Protection Bureau, involving them in the communications, because maybe these people will get picked up, these foreign agents. The re-aging of accounts is illegal. That's some information on it. Summary of rights under the Fair Credit Reporting Act. You want to get into that. Here's another template, Fair Credit Reporting Act lawsuit. Look at that. And they made this kind of like, I guess this was a complaint for violation of the Fair Credit Reporting Act, demand for jury trial. It says class action, but it's really written like a one-person injury. Excellent. I like this summary and overview, jurisdiction and venue. Notice these same things. Background, very short. These are very short to the point because a violation is a violation. So this is how you back them up, right? All the work is right here. Here's another one. United States District Court, Fair Credit Reporting Act, complaint. It doesn't say it, but this is Fair Credit Reporting Act. How do you know? 1681, right? The ongoing technological advances in the area of data processing have resulted in a boom of companies. You know, they're talking about credit reporting agencies. These are good ones too. 15 U.S.C. subsection 1681, Fair Credit Reporting Act. Kimberly versus Equifax. Look at these complaints. Right there. So what happens if you keep writing them letters? This is the next step. Here's another complaint. Plaintiff's original complaint. Always jury trial demanded. Why jury trial demanded? Because you're dealing with big corporations, and juries are people like you who've had their credit and things messed up, and that's when you can get into punitive damages. See, people don't. The FDCPA, yes, $1,000 per violation, but when you add in Fair Credit Reporting Act violations, and when you read the FDCPA, they're already suggesting within the act itself that punitive damages can be combined, because this is, like I wrote this right here. This is out of 15 U.S.C. 1692. Abusive debt collection acts contribute to personal bankruptcy, marital instability, loss of jobs, and invasion of individual privacy. They basically told you they contribute to that. So when insurance says you contribute to something, that means how much did you contribute, how much you got to pay out. So they say abusive practices does contribute to that. So these things of personal bankruptcy, marital instability, loss of jobs, if you suffer these type of damages, those are the type of damages that gets up into the millions and things like that. So the $1,000 per violation is one thing, but these other type of damages is something else. That's why you go for the jury trial demanded and all of these things. Many companies are afraid to be in front of a jury trial about a debt that they can't validate anyway when they don't have no contract to prove the validity. So you can go down here. These are more summary of rights. These are more lists of things under the Fair Credit Reporting Act that they have to remove, or that, you know, et cetera, et cetera. So yeah, there you go. There you have it. It's all there. It starts with the affidavit of identity theft. Get most of that stuff off. Get the rest of it off with a couple of letters and an intent to sue. If push comes to shove, take them to small claims court and get back with us and let us know how it goes. Now, I need you guys to do me a favor. I know you really enjoyed this video. Actually, I don't want you to do me a favor. I want you to do yourself a favor. Please do me a favor and look at the opportunity, the Bitcoin opportunity that's below this video. Do that for a brother. Peace.